You're listening to On The Docket with Napoli Shkolnik.
Hi, and welcome to another episode of On The Docket with Napoli Shkolnik. My name is Patrick Lanciotti, and I'm a junior partner here at the firm, and I work in the environmental department.
And my name is Andrew Croner. I'm also a partner in Napoli Shkolnik's environmental department, and I'm the head of the environmental department. And I'm excited to be here to talk to you, Patrick, about, as you said, I think a couple of litigations that you and I have spent a lot of time on, PFAS and lead.
Yeah, at the firm, we're currently working on some old legacy cases that we've been litigating for quite some time, while also investigating some new exciting cases involving lead exposure from actually a copper smelter out in Arizona, which I'll get to in a little bit. But lead is a very interesting contaminant, one that's been around for thousands of years, frankly, and we really just started learning about the dangers of lead in the 70s and the 80s. As I'm sure you may recall, there was a tremendous amount of lead in gasoline and a lot of exposure from leaded gasoline, and there was a concerted effort in the United States and really around the world to try and reduce the population's exposure to lead by removing lead out of gasoline, as well as in paint.
I was going to say lead-based paint is obviously one that springs to mind when you talk about lead contamination.
Which there has been a great deal of success in the United States, at least, to reduce general population levels. However, and primarily what we're seeing in the litigation front is these primary and secondary sources, these primary and secondary smelters, where they're still mining lead. For the most part, internationally, in the United States, primary smelting is banned. It's been banned since the 90s. And so that brings us to one of the litigations that we're working in La Jolla, Peru, as well as the second, as I mentioned earlier, the secondary smelting. So for the most part, those are the types of cases that we're seeing from the industrial exposure. And I know talking about industry, you can't talk about industry and what we do on a day-to-day basis without talking about PFAS. So if you can.
Yeah, we can shift that. And let me just, talk a little bit about what PFAS are and what our involvement has been with PFAS, to date. PFAS are per and polyfluoroalkyl substances. These are synthetic chemicals, man-made chemicals. But before we go there, just more generally about PFAS, they're known for certain chemical properties. That's why they were originally invented. They are very resistant to heat, very resistant to biodegradation. That's just the breakdown of different substances in the environment. When you put if you put your trash outside, eventually it's going to decompose. That process really doesn't happen to these chemicals. That's why they're often referred to as the forever chemicals. And those sort of properties made them very attractive for different industrial applications. And unfortunately, they're also the same characteristics that make them sort of a significant pollutant and something that is difficult to deal with as far as, having it be in the environment and be ubiquitous in the way that it is today. I will say one thing that's a little bit different about PFAS and lead is how long we've really known about it. There's an interesting, movie that, like, if you get involved, again, in PFAS litigation or know a little bit about PFAS, you may be aware of, which is Dark Waters, which is about sort of how these chemicals first came to light. Rob Ballat, who is actually, on an executive committee of a litigation that we're involved in, he was, one of the first people to really start to focus on these chemicals. He represented a family friend in West Virginia in litigation against DuPont to clean up his property. That eventually led DuPont to produce documents about these chemicals. It was really the first time that anybody outside of DuPont had really known that they even existed. That led, and that litigation ultimately led to more regulatory scrutiny from EPA about certain types of these chemicals. And for DuPont, the key one was that PFOA. That's what 3M sold to them, that essentially is Teflon. PFOA is Teflon, and PFOS is Scotchgard. which people are pretty familiar with, the 3M product. That PFOS is what 3M used as far as PFAS for different applications. And, one particular application that both of those companies were involved in, 3M in particular, was the use of those chemicals in firefighting foam. So, back in the 1960s and 1970s, there was a problem on a lot of naval, particularly naval ships, when they would have jets on there. There would be these jet fuel fires that current firefighting foams just weren't very good at addressing. And so you had a lot, there was I think it was in the 60s, the USS Forester disaster, where they couldn't put out one of these gasoline fires, and it just spread, and it ended up being a disaster, hundreds of lives lost. And so there was a real desire at the U.S. military to try to find something better. And so what they did is the Naval Research Laboratory learned about these chemicals that 3M was producing, and sort of, they partnered together to develop a type of firefighting foam that would, that would be more effective for these gasoline fires. And so I think I mentioned before that PFAS are very resistant to heat, to breaking down during heat. And so that property and some other, chemical characteristics of these made it so that they would really kind of suppress, the gasoline, and make it so that, these wouldn't, because one thing that you worry about with gasoline fires is that they're going to catch more, because you have the exposure to fire, the exposure to oxygen, and then the gasoline all in one place. And that's not a very good combination when you're talking about, combustion and fires. And so these were effective on, they were effective to be used in these firefighting foams to fight these jet fuel fires. The problem is, while, these companies that manufactured, the firefighting foam, they knew certain things about, the chemicals that they were putting in. They knew what the chemicals were, for instance. The government did not. They withheld that information. They said it was proprietary. It was a trade secret. When they did internal studies of health effects related to these chemicals, they didn't disclose that either to regulators. And so it really wasn't until, as I mentioned, this West Virginia litigation by Rob Ballard in like the late 1990s that any information about these chemicals really came to light. And so what we've seen over time is just that information building, where that West Virginia litigation led to a sort of a large-scale population study of health effects, with exposure to these chemicals. They did find, and we're going to talk about this in particular because I think it's really defined in many ways the scope of the personal injury litigation with PFAS. But that study, which was born out of litigation essentially, identified certain injuries that are associated with, and there's been more evidence that has supported this, that are associated with exposure to these chemicals. And so, firefighting foam, because it's sort of discharged right onto the ground, is one of the more ubiquitous types of products that actually has led to PFAS contamination. As I mentioned, these companies had all the information. They didn't disclose it to the military. And so, the military and civilian airports where they had to use this stuff, they trained with it. They even when there wasn't like a live gasoline fire, they were out there spraying this stuff all over the ground, not knowing that, it could cause any issues, not knowing that it was, chemically, it was particularly adept at getting into soil and leaching into water supplies. And so that's what's really created this problem, because these chemicals did do that. They did get into drinking water supplies, and they've exposed all of us to some degree, but really some communities located by these military bases, by these civilian airports, to just excessive amounts of these chemicals. And the medical research and studies, as I mentioned, it's still kind of catching up because while it has been, at this point, I guess 25, 30 years, you look at something like lead and that seems kind of short,
Sure.
because I think the problems with lead have been known for much longer, and it takes some time for the medical, research to kind of catch up and establish, exactly what, how big of a problem it is and what injuries you're associated with. And so, so our, as far as our firm's involvement, we've been involved in various types of PFAS actions, but by far, our biggest investment as far as, time and resources has been in a multi-district litigation, or MDL, that is located down in South Carolina, where they have taken basically all the cases that relate to the firefighting foam and put them in front of one judge down there to try to litigate them all, basically address the issues that are sort of common to either all of the cases or at least large groups of those cases, resolve all that stuff, and then send the cases back.
So when you say send the cases back, or all these cases, where are they coming from? Are they filed in all 50 states or international?
That's what's interesting, a particularly interesting aspect of and I know we're not focusing this particular conversation on the AFFF litigation, but I think we have to talk about it because it really does define a lot of what we're going to be doing now with personal injuries and PFAS in general. But one thing that's interesting about that multi-district litigation, or MDL, is that there was a particular defense that the defendants had, the government contractor defense, which I won't go into details, but is essentially a federal defense. And so if they want to be, if they're going to assert that defense, they have the right to then get that case into federal court. And so basically, any case that you filed related to AFFF across the country, if you filed in state court, they would get those cases into federal court. And then once they got into federal court, they would get them into this MDL. And so unlike a lot of other of these kind of sprawling kind of multi-district litigations, where often you have a federal multi-district litigation like we have in South Carolina, but then you also have parallel litigation in all state courts because you have other people that have filed cases about the same subject matter, but they're in state court. They have to stay in state court, and the defendants can't get them into federal court. With the AFFF, they were able to do that, and so really all of the AFFF cases are just in this one court. And I think we'll talk a little bit about how that informed our strategy a little bit with personal injury, and how that, I think is continuing to inform our strategy a little bit about personal injury with respect to PFAS. But, for a long time, basically up until we reached, significant settlements for cases not involving individuals, but it was municipal water suppliers. Basically, we were representing the water suppliers who had this stuff in their systems, need to pay to treat it and remediate it and to get those damages. We were one of three firms that was co-lead counsel. Eventually, a fourth was added. Up until the point I think that those settlements were made, and then due to different conflicts, we took a step back and are still on the executive committee, the plaintiffs' executive committee, but no longer technically a co-lead of that litigation. But I also think that some of that is, we've also shifted our focus a little bit outside of the MDL now that, that's, I don't want to say, there's still a lot of work to do there, but it's certainly advanced to a point where, you're kind of looking towards the next thing. And I think that's part of what we're going to talk about. So yeah. I know that's a lengthy introduction into PFAS, but, this is something that, frankly, I've spent 6 years of my life on, and it has been quite a journey. So I figured to do it justice, I had to go into a little bit of detail there.
Thank you. That's very helpful. And, I think changing gears a little bit, and you hinted at it, there was a time in the early days of this multi-district litigation that we're talking about now, where we were filing a certain type of case, certain group of cases, and like you said,
I think it's funny
the process
because
has kind of informed our decision of where we're heading. So
yeah.
I just want to maybe talk a little briefly about what we were doing and in terms of the dockets that we were investigating and filing and the folks that we were representing, and kind of where we see the future of the PFAS litigation kind of moving forward over the next couple of years.
Yeah, and I think it's interesting to have the two of us be the people that talk about this, because in some ways, you, I think, actually know more than me about the inception of how we got involved in these PFAS cases. You know, I think I came on in February 2020, and I was, you know, sort of filling in a spot, and you had about every case in the firm on your plate at the time, and so I came in and at that point, you know, sort of took over, you know, leading those AFFF cases, but you've continued to be involved in PFAS litigation, and in particular, we're involved in those early ones where I think, you know, initially our focus was finding these communities that were most impacted, where you had, you know, because one thing you look for, and one way to sort of identify areas that, you know, potentially need representation, that potentially need help navigating, you know, these types of legal issues, is often it's, you know, it starts with you know, a government or regulatory investigation of some kind. So what you started to see, I think, in probably around like 2016, 2017 is, you know, because they were finding out about the firefighting foam issues, they were finding out about the PFAS issues, the U.S., you know, government started to investigate these military bases, and they found some pretty startling stuff. I mean, so, you know, just that that there were these communities that had such significant contamination from the use of firefighting foam in those communities. And so I think initially our strategy as a firm, and again, I almost defer to you on this, Patrick, was to focus on, you know, what are, you know, the areas that have the most significant contamination or have the most exposure for populations. Like, what are the, you know, the places that really, this is the worst problem, you know, even compared to other communities that have seen this. And I think we had cases out in Colorado Springs, Peterson Air Force Base. I know some in New York that you probably remember. Newburgh, right?
That's right. Yeah.
You know, and then Pennsylvania too was another one. I think you've originally, you know, brought, you know, kind of filed all those cases that ended up in the MDL, right?
I did, and I think it's also important when we're talking about PFAS and the types of cases that we're seeing in the MDL. PFAS is not necessarily limited to firefighting foam.
No.
And so there are, talking about cases that I filed initially in about 2016, we pursued litigation against certain defendants who owned a facility who used PFOA and PFOS in the coating process of fabrics. And so you touched on this a little bit earlier. PFAS, PFOA, and PFOS, these chemicals are just one component, one of their uses rather, is in AFFF firefighting foam. There's, as you mentioned, thousands of other uses that you can put these products in to effectuate any type of, you know, product or any ability of
the non-stick is a big thing. Like, you know, I know another, you know, and I think it's been the subject of litigation, is fast food packaging.
Right.
You know, the reason why your burger doesn't stick to the packaging that it's wrapped in is there was a little bit of PFAS in there, and you know, and so that's why you're looking at such ubiquitous exposure. So yeah, again, I mean, I know you had other cases initially. You know, some AFFF, some not, but they were all kind of geographically focused, I think, right?
All geographically, yeah. So we were focusing on communities, like I said, in Hoosick Falls and in New Hampshire. There was another, what we call point source, and by point source I mean typically a manufacturing facility where they're using the PFAS or any chemical for that matter that's getting emitted, whether into the soil, air, or groundwater, and it polluting the community and their environment around them, causing potential health effects. And so we were pursuing cases for these point sources. We were also looking into, as you said, the use of firefighting foam in various military bases and various training facilities. Not only that, but you mentioned, you know, firefighters practicing and using these firefighting foams. I mean, that's another major location that we were seeing across the country, and even still to this day, where the training drills were taking place. They were using these firefighting foams, unbeknownst to them that they were potentially cancerous and had all these issues of being bioaccumulative and then can persist in the environment. And so we really, again, to your point, we were focusing on individual locations. And then that kind of ballooned into, well, not only what we're learning, and as the EPA and various governmental agencies were learning, is that this is a nationwide problem. This is a worldwide problem. This is not limited to just a point source or limited to one fire training facility or one military base. This was used at virtually every military base across the country and around the world. And so you're looking at a tremendous amount of people who've been exposed, and the idea of going into one community and investigating and filing individual cases on behalf of those people became a little it wasn't tenable for the firm. And so we looked on a more broad scale, representing individuals who were, and this is I think where you started joining and joining the PFAS fight, looking at individuals who were exposed really at any governmental facility, military training base or military base, and seeing what that exposure looked like and what those injuries were, we were seeing. And I think you could speak to this, I think, but we're typically seeing the same injuries throughout the various jurisdictions, throughout the different investigations that we're looking at. So I don't know if you want to talk briefly about some of the developments in the science for PFAS.
I mean, I think as you said, the focus was sort of on a site-by-site basis, finding a community that would have been impacted, and maybe we would represent a municipality there, but we would sign up, a lot of individuals who have had injuries that appear related to these chemicals. I do think. And I think it was probably disappointing initially when the MDL was created, because I know in Colorado Springs we got pretty far.
We did
in that case. I mean, almost to the point of class certification, right?
We had filed our class certification briefs.
I
think we had a hearing.
Discovery had been done, and so we were really out there at the forefront. And then it was like everything kind of had to get shut down a little bit while all the different cases got transferred into the MDL, and the judge there decided how we were going to, coordinate everything, and, what would come next, and is still doing that to this day. But I think what became clear, and this is certainly true in the past few years. I think a few things happened. I think when there was the large settlements that happened in 2023 with 3M and DuPont for public water suppliers, and these settlements, they totaled about $14 billion. I mean, huge settlements, made a lot of headlines. With the B. Because of how pervasive this problem is. I think that kind of was a signal that that's how other types of cases in this MDL are going to resolve. It's going to be global. It's not going to be, we're resolving the claims that this community has for this contamination site. It's going to be some sort of global resolution. And so, I think that changed our thinking as far as, what is, what's most beneficial to us and to our clients, as far as, putting ourselves in the best position, both to get the best recovery, but also to have like the loudest, voice that we can, because, these settlements are going to be for thousands and thousands of different, clients and other people represented by other firms, and everybody's trying to have a say in, what terms get in and how things are getting compensated and allocated and things like that. And so, and I think you were involved in this as well when we were both working on the litigation at the same time. But I think we started to take a more nationwide focus as far as signing up personal injury cases, because, we foresaw that it was going to be resolved in largely the same way. And we have not gotten to that resolution at this point. Frankly, in at least in that MDL, we're at a little bit of a we stalled out a little bit while the court is trying to figure out how to deal with this enormous docket of personal injury cases there. But I do think that all signs are pointing towards some sort of global resolution, and so, and I think the other thing that's happened in addition to those public water supplier settlements is the court has taken some action with the personal injury cases that have influenced this. It's been trying to streamline that that docket to reduce the number of cases because it just seems so overwhelming, I think, to the court. One thing it's done is, and we'll talk a little bit about this, I think, in a minute, is, it's sort of settled on a core set of about 6 injuries that, at least it agrees need to be litigated between the parties as to whether or not they are, causally linked to exposure to these chemicals. The other thing is, the court became very concerned that there was a lot of people that had not filed their personal injury cases, so it entered some orders this last summer, basically forcing everybody to file their AFFF cases, all of them. And if you don't, you're subject to having to get an expert report and all sorts of other requirements that are really meant to be, kind of punishments for not getting your cases filed quickly
with the idea that
on time.
The multi-district litigation was just getting too big.
It was getting
there
too big.
Too many cases filed,
Exactly.
and so the judge was just trying to wrap his arms around it and figure out what do we need to do to bring this to a resolution. Because, as you know, I mean, the multi-district litigation was established in 2018, I believe.
Yes, December 2018. Yep.
So typically these multi-district litigations, they do take some time, but there is progress that's made.
Yes.
And while there has been a great success with the public water supplier settlements, the personal injury cases, and really those were the ones that started it all, like what we talked about, the Colorado Springs case that we were representing folks out in Pennsylvania. Those were the cases rather that we really paved the way for this multi-district litigation to begin, and there still has been no resolution for those cases. And so I want to ask,
and I mean, really, it's prevented progress in other types of cases. I mean, that's the thing is, again, unlike other types of mass torts, where environmental, a lot of times you do see this, but if you ever worked in like pharmaceutical mass torts, I mean, you're talking about just personal injury cases, just representing individuals. You're not seeing, representation of different municipalities for not only water contamination, but also property damage. So there's all different types of cases, but there's this chokehold right now in the MDL because of the size of the personal injury docket, and the trouble that the court has really had getting its arms around it. And so, I think now, though, we're at a point where that court has sort of forced everybody to file their cases in the AFFF, and so we're now looking to what's next. And I think it's funny because I think we're going back to the start a little bit, and we're looking at, okay, if all the AFFF, all the sites and communities where the PFAS contamination is AFFF related are in this MDL and probably going to be subject to this global resolution where we've basically filed all of our cases. What's left is other types of PFAS contamination. As you mentioned, they're using all sorts of different, not only products like end products, but they are using a lot of different manufacturing processes. I mean, they are processing aids for a lot of different things. I know chrome plating is one. I think semiconductor manufacturing is another area where like PFAS is used in the production process. And so what you do see is now you see these other types of communities that have been impacted by PFAS contamination, but it's not because of use of firefighting foam at a military base or an airport, but it's because they had some plant that manufactured, either a product that contained PFAS, or at least you had to use PFAS in the manufacturing process, and now they're being contaminated. And so we've gone back to this focus on, different, geographical sites. We're trying to identify those sites where, there is significant contamination that that we think we can trace back to, to a local defendant or group of defendants, and try to go into those communities and get, represent the people there and try to get them some recovery for being exposed to these chemicals when, it really wasn't their fault. Often the companies that were involved in these manufacturing processes, were similar to the manufacturers of AFFF in that they knew what these processes were. They had a little bit more knowledge of what these chemicals were and what they were used for, potential issues with them, and they didn't let anybody in the communities know. And so, it is interesting to go back, to sort of that initial focus that we had, I think, at the start of, the PFAS litigation with AFFF, and now we're sort of doing the same thing with, what the other types of contamination that are left out there. And you've done some of those cases. I mean, maybe you want to talk about that experience with like Husick and. We even have the Amherst case, which is, I guess, sort of AFFF related, although it's not in the MDL,
Right.
which is interesting. So
Yeah. I do want to just touch briefly, just turning back to lead for a moment.
Yeah.
To talk about, when we were speaking about PFAS and some of the science that's been developing over the really short amount of time, over the last, several years, and just comparing that in my experience to some of the lead litigations that I've been involved in, specifically in the Flint water crisis out in Michigan, this case that we have that's pending in St. Louis, but on behalf of about 2,200 children in La Jolla, Peru, for a primary lead smelting facility down there, and some other new litigations that we're working on. But what's been interesting to see, and being in both worlds, both PFAS and lead, is how the science has always trended in one direction for lead, and how there's been a little bit of back and forth, a little push and pull with the science and PFAS. And I just want to talk briefly about the science of lead for a moment. We have really learned, again, over the last several decades, that any level of lead in an adult, in a child, in any human being is bad. Lead, while it's naturally occurring, it is a heavy metal that serves no purpose from a medical standpoint in the human body. When lead is ingested, whether it be through hand-to-mouth activity for children, ages primarily 0 to 6 years old, or through dermal exposure, or even through inhalation, the lead will move from the blood, and the body treats it as calcium. And so it moves from the blood into the bone and then into the brain as well. And that's where we see a lot of the injuries and the deficits, again, primarily in children who are exposed from early childhood, but also in adults. There's a lot of issues that we see in adults. And these are issues, again, that have been documented, and the science has consistently, through different meta-analysis, through different pooled studies throughout the world, in Australia, in Port Pirie, in the United States, no matter where you go, the evidence of lead's detrimental effects all say the same thing, that there is no safe level of lead. And so it's just interesting being, and we can talk about proving one of these environmental cases and the different experts that we need. There's a lot of overlap between what goes into a lead case, what goes into a PFAS case, or really what goes into any toxic tort exposure case. But just from my perspective in the lead litigations, it's very interesting, hearing a defendant try and say that any lead isn't necessarily bad for a child when there is, without a doubt, the CDC, every environmental agency around the world agrees that lead is dangerous. And so just putting lead to the side, and maybe we can talk about toxic torts in general and what we need to prove our cases, from a personal injury standpoint, if you want to touch on that.
Yeah, well, and I think it is interesting because I do think that there's less dispute today, certainly, about that there are health effects with PFAS, but I do think that there's certainly been some debate, or at least I think the defendants in those cases have marshaled their own version of the science there. Frankly, I think that's part of one of the reasons why the MDL court did not start with personal injury cases, started with these water supplier cases, is you didn't have to get into those thorny issues of causation, of medical causation, because a water supplier just needs to show that it needed to remediate, and that the remediation is going to cost X. They don't necessarily need to show that the chemicals cause kidney cancer or testicular cancer, et cetera. So maybe to take a step back.
Yeah, I was going to say, so what is medical
let's just
causation?
talk. Yeah, because I while I think we are looking forward as far as what's happening next with PFAS. I do think that in the personal injury context, a lot of both the types of injuries and what you're going to need to prove, individual exposure or to prove an individual's case is probably going to be defined by what's happening in the MDL. Because if you sue any of these, defendants, because, the AFFF defendants, like the 3Ms and the DuPonts, they were involved in using PFAS for a lot of these other, applications as well. And so you're likely going to see the same defendants, and they're going to tell the court, hey, this is what we did in the MDL, and we should do it again here. And it's going to be, so I think it is going to kind of set the standard in a way. But just to start with the injuries that are associated, or at least I think I mentioned that kind of core set of injuries that the MDL court in the firefighting phone in the AFFF has sort of settled on. And 4 of those injuries come from, I mentioned that West Virginia case way back when that started all of this. As part of the settlement in that case, they did this they sort of studied the whole population in this one town of Parkersburg in West Virginia, and saw what injuries were associated with the exposure to, in that community it was PFOA, and I think there were 6 that they found a probable link in that study. It's called the C8 Science Panel. And 4 of those I think the MDL court recognized, which are kidney cancer, testicular cancer, ulcerative colitis, and thyroid disease. The other 2 I think are preeclampsia and high cholesterol, which the court didn't. Preeclampsia is sort of on the court's radar, but it is decided not to address at this point. I think high cholesterol, the court just felt like it was too ubiquitous, which I don't think anybody really disagrees with. I mean, either you or your parent or whoever is going to be on a statin. Everybody kind of has high cholesterol, so that was probably the right move. Now, the 2 other injuries, in addition to the 4 that I mentioned, kidney cancer, testicular cancer, ulcerative colitis, and thyroid disease, then the court actually had us. The MDL court had the plaintiff's executive committee on the one side, and then the defendants on the other, go through this process of deciding what injuries the executive committee was going to support and actually try to prove up as being related to or caused by these chemicals, and we arrived at 2, thyroid cancer and liver cancer. And what we have sort of told the court, and we're still in the process of doing this. We actually have Daubert motions that are going to be filed at the end of this month. Frankly, I don't think the plaintiffs are going to file any with respect to the defendants' experts, but we put up experts to basically support that thyroid cancer and liver cancer are associated with exposure to these chemicals, and so they're going to now, I'm sure, file Daubert motions about those opinions, and so we're going to see where we land. I think that the court is kind of mixed on that. I think the other 4 that I mentioned, particularly the kidney cancer and testicular cancer, we've gotten a lot of indications that the court seems like there's pretty robust evidence there and would likely go with us on that, but we don't know because we have Daubert motions pending with those injuries that have just been pending for quite a while. So, but that's sort of the universe that's been defined. And so I think when we're thinking about taking and building up an individual case or individual, even if it's an individual community's cases, the first thing we're looking for from a personal injury perspective is one of those kind of 6 injuries. And then you talk about now that we've gone through, some processes about trying to how exactly would a personal injury settlement, what would that look like? What would it require? We're seeing that I mentioned there was the filing deadline for the personal injury in the AFFF. Well, now another requirement that the court said is you have to have medical records that not only establish that you had that you had the condition, that you were diagnosed with the condition. They don't necessarily have to be contemporaneous. It doesn't have to be like the record that diagnosed you, but you must have some reference in your medical records to having one of these injuries. And if you don't, then your case is going to get knocked out.
Right.
And so, at this point, we know that's one thing that we need whenever we're taking an individual's, case, because even if if it's a PFAS case that isn't going to end up in the MDL, the likelihood is we're going to need that at the very least to make a claim under any sort of settlement or anything like that. They're going to want that
proof of injury.
That proof of injury.
Yeah, proof of injury. Just pivoting back again to lead is a little different. Because the exposure to lead and what we see as the detrimental effects to lead can be longitudinal, and by that I mean we don't know what the true effects of a pediatric lead exposure can be until several years, decades later. Primarily, a child who's exposed at early childhood can have IQ deficits. They can have behavioral issues such as ADHD and hyperactivity, and they could also have neurocognitive issues. And so, a lot of times that doesn't manifest itself. So when we're doing, until several years later,
you have to have special, like some sort of special kind of testing or that's done to evaluate that, right?
Yeah.
So that's
so
very
I mean, in terms of the experts that we need on a lead case, we bring in a pediatrician who comes in and says that an individual's lead exposure is causally associated to the detriments that they're experiencing, the deficits that they have, and that's tied with a neuropsychologist, a certified neuropsychologist who comes in and does a battery of exams depending on where that individual is located, their cultural backgrounds, making sure that the exams that are given in the United States may differ than what you would give a child who's in Peru because they have different cultural norms, and so an exam may look a little bit different. But we need those two experts and a variety of others to help prove that case and see, even though a child, we may be looking at a child who's 16 years old today and who's exposed in that early 0 to 6 range, we may know some of the issues. They may have some IQ deficit. They may have some behavioral problems. But we don't know what's going to happen when they turn 20 years old or even 30 or even 40. I mean, that's just a longitudinal effect of lead. And just talking about the proof that's needed for a PFAS case, we need that medical record that says this individual has cancer. It's a little bit more challenging on the lead front because what we really need is the exposure. Yeah. We want to know at the time of sign up that this individual lived for a certain amount of time in an area that there was environmental exposure that would be a sufficient dose for these injuries to lead. And one of the challenges in determining what an individual's lead exposure is, lead, as I mentioned earlier, goes into the blood. After ingestion, it goes into the blood. But lead only has a half-life of 30 days. Yeah. And so, as I mentioned, it then moves into the bone. And so if you don't get a snapshot in time of a blood lead test, for example, to see what an individual's blood lead level is at that moment, and you wait 30 days, and then you take that exam again, a blood test again, that's going to be a completely different level. So what we've tried to do, and we were successful in Flint, is using what's called an XRF device, which essentially there are portable machines and there are stationary machines that are only located in some hospitals in the United States, and very rarely are they available internationally. But an individual will take a portable device and scan the tibia in the leg, and we're able to see what the new lead level is that would have been in the blood that's now migrated into the bone, to give us a good sense, again, of that dose. Because that dose is important to know what is an individual's cumulative exposure, and the pediatricians and the neuropsychologists and our vocational rehabilitation experts who look at the possibilities of what this individual can achieve, whether in the educational front or in their professional lives, as well as our economist who we bring on, a forensic economist who says, based on the statistical data, this individual is likely to make X amount of dollars in an urban or a rural setting. And so all of this information, from the dose, from the exposure length, is important for our experts to really build a case and is able to tell us what these injuries are and what the potential damages for each individual case is. It is, at the end of the day, a very individualized analysis because lead impacts everyone differently. You could have a brother and a sister who live at home, have the same hand-to-mouth activity, play in the backyard, eat from the same vegetable garden at home, and have varying different lead levels. There's no rhyme or reason to how lead impacts the cells in our bodies. It can impact you and I differently. And so that's very important when we're looking at these cases on an individual basis. And so it becomes a challenge, without a doubt.
Sure. It sounds like it's almost the you know, sort of the inverse of what we deal with PFAS. Like,
right.
in many ways, you need to be able to show the damage, right? But if you establish the damage and if you establish the exposure, there isn't much dispute that they're linked, right?
Right.
I think for PFAS, we can get the damage, which is the diagnosis with, kidney cancer, testicular cancer, whatever. We can have the exposure, but where our expert focus has to be is putting forth the best case we can that the two are connected. Because, as I said, there has been some dispute. There are studies that kind of go in both directions, even with the best of the PFAS injuries. I think that's the nature of epidemiology, particularly in the environmental context. And this is something that we tried to really emphasize, in the MDL, in part because there had been some unfortunate opinions that the same judge had given in a pharmaceutical case, and we were trying to explain the difference in, like, pharmaceuticals. You can have, certain types of studies done, randomized controlled trials that really give you, pretty definitive evidence on health risks and things like that. You can't do that in environmental exposure cases, and so it's just kind of a different, it's a different. You have to look at that data sort of differently. So that inconsistency is something the defendants always harp on, but it's frankly not unexpected. The other point I just wanted to make is, I mentioned having medical records that, establish the diagnosis, and that may seem like it's a low bar, like how could somebody not meet that? And, in some ways that might be true for like a kidney or a testicular cancer, but when you get to certain other types of injuries, I think, there can be a dispute. And we're seeing that a little bit with ulcerative colitis and thyroid disease, I think for kind of different reasons. Ulcerative colitis is, it's a gastrointestinal, disorder, but its diagnosis is very, very close and almost subjective compared to something that I'm sure like other another condition that people have heard about, which is Crohn's disease. We've been told by experts that, it can be very difficult to choose. It can really be a matter of opinion in some ways, like if something is ulcerative colitis versus Crohn's disease. And so we're now in a situation where it's like we may have a client who our expert says, no, that's definitely ulcerative colitis, but their medical records just say Crohn's disease. Mm-hmm. And so we're fighting about that, about, whether how do we get the medical record proof we need for a client like that, where, we have information suggesting that they have a valid injury, but it's not really reflected in the medical records. And thyroid disease is sort of similar. It's a similar situation, but for different reasons. Thyroid disease, the problem is just that term kind of encapsulates a few different types of conditions. You can have hypothyroidism or hyperthyroidism, whether your thyroid is working too much or too little. You have certain, particular conditions such as Hashimoto's disease, and trying to think, there's one more that I can't remember sitting here on the spot. But
did you mention Graves'?
Graves, that's the other one, Graves' disease. They all are technically thyroid disease, but they obviously have different names. And so just want to point out, like, those medical record requirements, while they may seem like they're not, particularly onerous, we're talking about, first of all, about injuries that may have been diagnosed a long time ago, or that, someone hasn't been to see a doctor in a few years. It may be tough to get their medical records. And, the different terminology and some of these nuances with how things are diagnosed can also impact. So, it's one way of saying that, when you have serious injuries like that, we always appreciate clients who are good historians and keep a lot of their records, because it does make it a lot easier later on.
Yeah, and I mean, a lot of these doctors, can be retired, and you can't really bring them in for a treating physician deposition and ask them questions about, hey, why did you make this diagnosis, and why didn't you do it the other way? So it's definitely important to have good client participation. And I think as we kind of transition into talking about our clients, I want to just talk a little bit about kind of expectations. As you know, we talked about the multi-district litigation was established in 2018. I was filing cases for PFAS back in 2016, and some of those folks still have not gotten any resolution. And so I just want to briefly talk about expectations and what our clients can expect when joining in environmental litigation. And unfortunately, these do take some time. These are highly complex cases, some of the most complex cases that you could find in the legal landscape. There, as you mentioned, there are various defenses that defendants will raise that can take years. Sometimes they go up on appeal, and you're at the whim of an appellate court that can take a year or two to make a decision on one issue. And then you get back to your jurisdiction, and then now you have the actual work that needs to be done. And that litigation sometimes can take time. I mean, in La Roya, Peru, for example, the defendants produced 2.1 million documents and not pages. And so that's a tremendous amount of work to go through all of that material and go through the needle in a haystack process to find those good documents that are really going to help prove the case and show that that defendant in particular knew of the dangers that they were participating in at the facility that they were operating. And so, just in terms of client expectations, if you could just comment a little bit about, some of the time frames, some of the issues that we run into in the environmental field.
Yeah, well, I mean, the other thing, you mentioned the complexity, and there's probably not a better way to say it, but these are also cases that require significant investment. And that's because of the amount of expert work that is needed. Because of that complexity, so many issues in the cases, have to be addressed by expert testimony. So we have to go out, we have to find the right expert, they have to be able to do their investigation. And this is not just like, is exposure to these chemicals leading to these injuries? That is a significant part of it. But for these types of cases, we also need, engineers that can, actually understand how the contaminants, could have, gone from the factory to wherever the plaintiff was located and actually expose them. Was it through water? I think we talked about the difference, with PFAS, so much of the focus is on water contamination. Because these are chemicals that are known to get into the soil and to get into water sources quite easily and efficiently. But I think you mentioned in the lead cases, a lot of it is more about air emissions from the smelters, right? I'm actually there's a PFAS case we have down in North Carolina, and I think the Fayetteville. Yeah. There they have air emissions, so we're actually, I'm starting to learn a little bit about that, but I think it's something that you're much more familiar with, having worked on all the lead cases. Right?
Yeah, learning terms like mod flow and different
fugitive emissions.
Yeah, it's definitely been a fun process for sure.
Yeah.
I want to close and talk a little bit about accountability. A large part of what we do in our environmental department is obviously putting our clients first and making sure that we're doing the right thing by our clients. These are people who are coming to our firm and they've been exposed to some type of contaminant. They have some type of personal injury, and it could really destroy a person's life, and they really have nowhere else to turn. And that's, I think, a really important part of what we do, and part of that is holding defendants and holding companies accountable for the actions that they take. At least on the lead front, we're looking at companies who know the dangers of lead. They know the types of emissions controls, for example, that they need to have in place so that they won't be polluting a downstream community. A lot of times, unfortunately, that we see not only in the environmental field but in complex litigation and commercial litigation, is that big corporations will put their bottom line first before community. And at least, just litigating for 10 plus years in Flint, Michigan, decisions are made by corporations, unfortunately in Flint's instance, by governmental entities, both on the local, the state, and the federal level, that negatively impact disenfranchised communities. And so lead smelting facilities, typically in the United States before they were shut down, but now internationally, are located in third, even really fourth world countries because it's cheaper and there's less public backlash to pollute a poor community, rural community in La Roya, Peru. And I've had the blessing to go and visit our clients in Peru. And I mean, these are absolute salt of the earth people, the nicest people you would ever meet. And it's really unfortunate to see the struggles that mothers have and raising children who are born with elevated levels of lead. I mean, these kids really had no chance from the beginning. And so I know there's a lot of accountability that is involved in the PFAS litigation that you've been working with, you know, in terms of companies like 3M and DuPont, and you touched on this earlier about their knowledge of what they knew.
Yeah, well, I mean, to go back just to I know that in La Roya, I mean, there's an example from what little I know about that case of them applying one standard for how they dealt with environmental issues in the U.S. because they had a U.S. facility that was very similar to the one that they have in Peru, and they took a completely different approach. And so that's, I mean, it doesn't get more clear cut than that. I feel like as far as corporate accountability, you know, I think in the PFAS space, I mean, 3M continues today to, you know, dispute that you know, these chemicals are associated with health effects, which seems, you know, we're all kind of incredulous about given the mounting evidence. But, you know, as you said, I mean, these companies often look at what it means for their bottom line. And you think they learn because you know, I think that's what they were thinking when they first had the opportunity to deal with this problem. We've seen the documents from the, you know, 70s, the 80s, and even into the 90s, you know, and really they, you know, their strategy was to form, you know, containment committees and things like that, rather than be upfront with the public about, you know, what these chemicals are and what risks they pose. I mean, it's particularly bad here, you know, look, with what's happened at communities impacted by lead is inexcusable, and I don't really want to compare it like it's apples to apples, but the thing with PFAS is we've all been exposed. You know, this isn't you know, a situation where, you know, it's just one community because that's where they did the activity. I mean, this stuff has become so ubiquitous that all of us have been exposed to it. The question is, do you have enough exposure to actually you know, have health effects? And that's a pretty sad state of affairs for you know, for the companies that produce these chemicals, that, you know, essentially they you know, infected the entire population, and nobody really knew any of the effects until after they were already exposed. And you know, I really do hope that you know, what's happened with you know, 3M and DuPont and these companies will be a lesson for the future, and frankly for regulators, for EPA, you know, because these chemicals were allowed to be produced and, you know, circulated globally for a long time with literally no one knowing what they were, what risks they posed, other than the companies themselves. And I just don't think you can put, you know, we as a society can put ourselves in that position, you know, anymore. We've seen too many times, like you've seen, you know, with the lead cases, and you know, whether it was Flint or, you know, any other number of different litigations we've been involved in, that we can't trust the companies to police themselves.
Right.
And so, you know, accountability, you know, for better or worse, I think it is left to firms like ours to make those companies be accountable and to commit, hopefully, to being more accountable in the future. But so yeah, I mean, I think that's certainly a guiding principle for us, you know, as we, you know, look forward in the PFAS space, and I'm sure it's the same for you with lead.
It is. Thank you again to Andrew. Join us next time for On the Docket with Napoli Shkolnik. Please remember to like and subscribe at the link below.